A federal judge is facing a wave of backlash after handing down what critics call a shockingly lenient sentence. In the case of a 2022 assassination attempt on Supreme Court Justice Brett Kavanaugh, 29-year-old Sophie Roske, now identifying as transgender, formerly known as Nicholas J. Roske, was sentenced to just over 8 years in prison on Friday by Judge Deborah Boardman of the U.S. District Court in Maryland. Roske was arrested outside Justice Kavanaugh's home in suburban Maryland, armed, and according to prosecutors, intent on carrying out an assassination. The Department of Justice had sought a minimum of 30 years, calling the crime a direct threat to the independence of the U.S. Supreme Court. But Judge Boardman ruled for just over 8 years, saying while Roske's actions were reprehensible, she also weighed mitigating factors, including Roske's spontaneous confession and cooperation with police. Online, conservatives erupted in anger, accusing the Biden administration's judiciary of going soft on violence when it targets conservative figures. Attorney General Pam Bondi called the sentence woefully insufficient and vowed to appeal. This isn't the first time Judge Boardman has come under the microscope. Appointed by President Biden, her judicial record and decisions are now being closely re-examined. We take a look back at her Senate confirmation hearing, where Senator Chuck Grassley and Senator John Kennedy grilled her on her judicial philosophy and independence.
Judge Boardman, apart from being a federal defender, you spent some time as a top associate working pro bono matters at a major law firm. First question, do you think law firms should allow their paying clients to influence which pro bono clients they take? And you can give a short answer if you want to.
Thank you, Senator Grassley. I did have extensive experience at a law firm doing pro bono work, and it was an extraordinary experience as a young attorney. To answer your question, no, I do not think that paying clients should have any influence on which pro bono clients that law firms decide to represent.
Next, should law firms undertake the pro bono prosecution of crimes? If so, which crimes?
Thank you, Ranking Member Grassley, for that question. In my experience, at the firm, we certainly did not take on the role of being a prosecutor in crime, so I don't have any experience with that. I would think that is probably best left to experienced prosecutors.
Last question in this area. Do you agree with student advocates that certain categories of clients, quote unquote, don't deserve civil representation?
I'm sorry, Senator, I don't know. I'm not familiar with the organization or the quote.
Okay, then why don't you answer that in writing for me?
Very good. I'd be happy to do so.
My second question, you have spent much of your career defending criminals from around the Baltimore area. Many of these cases involve defendants who were charged with unlawfully possessing firearms. Do you think Baltimore would be a safer place if fewer felons and criminals unlawfully possess firearms?
Thank you, Ranking Member Grassley, for that question. Certainly, gun violence is a very serious problem in the city of Baltimore. It's one that I can tell you, based on my experience, both as a magistrate judge and as a federal defender, that the United States Attorney's Office for the District of Maryland is laser focused on combating violent crime in Baltimore. My role, of course, in the process before I became a judge was to uphold the Sixth Amendment and defend poor people who were charged with crimes. And that, of course, did include the people charged with gun crimes in Baltimore.
Over this past year, COVID in prison has been a problem. Courts have needed to strike a balance that keeps prisoners safe and protects communities from dangerous criminals. You have some cases that concern me in this area, and I'd want to ask you about two, Gallagher and Spencer. So I'll only be able to go to one point I want to make. You released the prisoners in both of these cases, but the district court reversed you. Can you talk about what facts the district court relied on in reversing your decision? Then I'll submit the rest for answer in writing.
Okay, very good. Thank you, Senator Grassley, for that question. When I made those decisions, I, of course, was presiding over a detention hearing. That's one of my responsibilities as a magistrate judge. I considered the factors under the Bail Reform Act, which of course is the governing statute in detention hearings, and I found that there were that there were conditions of release that would reasonably assure the safety of the community and the defendant's appearance at trial. And then the district court judges disagreed with me on that, sir.
Judge Boardman, tell me what the rational basis test is.
Thank you, Senator Kennedy, for that question. I understand that that is probably the first level of review in a constitutional question, and certainly if that matter were before me in a constitutional matter, I would research the law, including Supreme Court precedent, binding Fourth Circuit precedent, and I would apply it where applicable.
What is it? Can you define the test for me?
I cannot, sitting here right now, sir. Whenever I'm faced with any new legal issue, I do the research and I find the answers through research in the case law.
Okay, so you don't know? Okay. What's a penumbra?
Thank you, Senator. My understanding of a penumbra are those rights recognized in the Constitution that are not specifically enumerated.
Okay. We know that privacy is a penumbra, do we not?
That's my understanding, Senator.
Are there any other Supreme Court holdings defining other penumbras?
Senator, I'm sure that there are.
Could you help me there?
I understand there's a right to travel that is not specifically enumerated in the Constitution.
Yes, ma'am. Anything else?
Again, I am sure there are, and I'm happy.
That's okay. Let me ask you one last question. When we look for a fundamental right in the Constitution, and we know from Supreme Court precedent that you and I have fundamental rights according to Supreme Court precedent, we have fundamental rights that are not expressly delineated in the Constitution. One example is the right to privacy that we just talked about. What is the Supreme Court standard for looking at the Constitution and saying, even though it's not expressly delineated, we think that Americans under our Constitution have this fundamental right?
Thank you, Senator Kennedy, for that question. It's hard for me to answer that in the abstract. What I do in every case when I'm presented with a question like that is I research the law and I find Supreme Court precedent on it. So in order to answer that question, I would need to do research to tell you what the standard is.
Well, let me ask, I'm not asking the direct answer. I probably didn't ask that very artfully. I'm trying to understand your appreciation of the state of law. Let's suppose I litigate a case and I say, I have a fundamental right to education. And my case reaches the United States Supreme Court. Now, I think we can both agree that the Constitution does not say expressly that I have a fundamental right to education for me, or let's say for my children. Let's suppose I'm arguing that it is implied in the Constitution. What test is the Supreme Court going to use to try to determine whether I or my children have a fundamental right to education, if I argue that it's an implied right, a penumbra, if you will?
Thank you, Senator. Certainly, it's very difficult for me as a sitting magistrate judge to speculate what the Supreme Court would do. But based on my reading of Supreme Court opinions, certainly the Supreme Court looks to the Constitution, the Bill of Rights, the 14th Amendment, the Due Process Clause of the 14th Amendment.
Okay. On an issue like that, a right that's not expressly stated in the Constitution, but it's very important, obviously. We know that absence of education is the root of a lot of our social problems in America. Which branch of government do you think is better suited to make that decision? the decision being whether I have a fundamental right to education. The legislative branch or the judicial branch?
Thank you, Senator, for that question. Certainly the role of the judiciary is to interpret the laws that Congress passes and the Constitution. To the extent that interpretation leads the Supreme Court to find a right to education, then that is within their province. Certainly the legislature passes laws to fund schools and to govern education. So each body has its own role.
But what I'm asking is, between the two branches, which branch, in your judgment, is better equipped to decide whether Americans have a fundamental right to education?
I think when it comes to interpreting the Constitution, that is within the province of the Supreme Court, and to the extent that there is a fundamental right to education that's recognized by the Supreme Court, that would be the law of the land.